Mr. President, Your Honors, good afternoon. My remarks focus on a dimension of the merits of this appeal, glaring legal errors which were omitted by the prosecution in its oral submissions today, but thoroughly covered in its appeal brief at pages 44 through 53, with which LRVs concur, and which are not directly mentioned in Your Honor's questions, but which we respectfully submit demand this Chamber's attention because of their dangerous implications and premature exclusion of crimes within the jurisdiction of the court from any investigation that may be authorized. The impugned decision includes egregious errors of law regarding the court's subject matter and territorial jurisdiction over the war crime of torture. The decision replaces sound and accepted analysis consistently applied in this court's prior jurisprudence with distortions of international humanitarian law. As we said yesterday, these errors have the effect of writing our client and many other victims of the U.S. torture program out of the scope of any investigation by the prosecutor. Moreover, if uncorrected, these errors would have the perverse, and we posit unintended, effect of endorsing the repugnant logic that formed the basis for the U.S. torture and extraordinary rendition program. Among the most glaring errors was the pretrial chamber's misinterpretation of the court's territorial jurisdiction over the war crime of torture when that crime occurred in part on the territory of a non-state party. The issues are complex and, with all due respect, are made more confusing by the pretrial chamber's muddled approach to its analysis. We will not repeat here the extensive discussion of these issues in the filings before the chamber, but we'll try to restate in simple terms what we submit the pretrial chamber got so terribly wrong. But let's start first with what the pretrial chamber got right. In paragraph 50 of the decision, the pretrial chamber correctly stated that if any part of a crime is committed on the territory of a state party, whether it commences, continues, or concludes there, the court has jurisdiction under Article 12. But the pretrial chamber then plainly failed to apply that understanding of the law when reviewing the aspects of the prosecutor's request concerning torture committed by U.S. actors. This was largely because the pretrial chamber misconstrued the conduct at issue, that is, the elements of the crime of torture, and how it was committed under the U.S. torture program. As my colleagues in LRV 3 will elaborate, the impugned decision abandoned long-accepted, fact-specific criteria under international humanitarian law concerning the nexus between given criminal conduct and armed conflict, criteria clearly set out in the June 15, 2017 Ntaganda appeal, decision 1962. We submit that had these well-established criteria been applied to the facts relevant to our client and many other victims of the U.S. torture program, the pretrial chamber would have found a reasonable basis to conclude that a nexus to the armed conflict existed. Instead, it focused on the locus of capture as the sole determinant of the requisite nexus. To restate in plain language the pretrial chamber's erroneous conclusions in paragraph 54 and 55 of the decision, on the one hand, the chamber said that if a person was captured outside of Afghanistan and then brought to Afghanistan and tortured, the crimes committed against him cannot amount to war crimes within the court's subject matter jurisdiction because it's the locus of capture alone that determines the nexus. On the other hand, it held that if a person was instead captured in Afghanistan but sent to the territory of a non-state party to be tortured, the crimes committed against him would not be within the territorial jurisdiction of the court. This dangerous conclusion appears to have rested on a fundamental misunderstanding of the facts and operation of the U.S. torture program. As I described yesterday in presenting the abuse suffered by our client, capture in the torture program systematically entailed kidnapping, sexual assault, and incommunicado detention before transfer to a secret location for interrogation under further torture. As Ms. Gallagher emphasized, cleaving off capture from subsequent acts of torture and referring to it as a mere antecedent misunderstands the continuous nature of the crimes, which were part of a coordinated, orchestrated transnational program, or, to use Ms. Gallagher's words, a criminal enterprise. The pretrial chamber's confusion on this point is especially troubling, since the US torture program was designed to exploit purported lacunae in human rights and humanitarian law, and to avoid the jurisdiction of courts, whether domestic, foreign, or international, that might otherwise shut the program down. Through misguided interpretations of international law, the United States sought to place detainees in a legal black hole, while also physically moving them to prisons chosen or constructed to avoid the jurisdiction of courts that might view the law differently. Particularly relevant to the impugned decision here, the US maintained that the protections of Common Article 3 of the Geneva Conventions did not apply to armed conflicts that were international in scope. We will not repeat what is well known. These legal arguments have been roundly rejected by courts that have had the opportunity to review them since the US launched its torture program many years ago. The US Supreme Court, the European Court of Human Rights, the UN Human Rights Treaty bodies, and the Inter-American Commission on Human Rights have all determined that no legal black hole ever existed, that the protections of Common Article 3 applied to detainees held by the United States in its secret prisons, and that they unquestionably had the right to be free from ill treatment and torture. The pretrial chamber's mistaken conclusions regarding the war crime of torture are not only legally unfounded and grossly underprotective, they also resuscitate condemned legal arguments precisely at the time in the United States when there is a manifest risk of recurrence. Allowing these aspects of the impugned decision to go uncorrected would put the ICC's imprimatur on the very logic underpinning the infamous torture program. We respectfully request that the Chamber correct these legal errors in its decision on this appeal, reverse the impugned decision, and authorize the commencement of an investigation into the situation in the Islamic Republic of Afghanistan that encompasses the severe violations our client and other victims of the US torture program suffered. With all due respect, we note the conspicuous absence from the remarks by the representatives of Afghanistan of any evidence of efforts to investigate or prosecute crimes committed by US actors in Afghanistan. Our client has been denied justice for nearly 15 years since his release from US custody in Afghanistan. We ask this chamber to carry out its role as a victim-centered court of last resort and authorize the investigation into the situation in the Islamic Republic of Afghanistan. Thank you.